Hi, you guys. Brittany here. I'm a recent law school graduate. I graduated in 2020 and then I took the bar and passed the bar, at the end of the year 2020. So I am a licensed practicing attorney now in Pennsylvania. I just wanted to put together some sample questions and a slideshow for everyone who needs some additional help or who is struggling with bar exam questions, because I know that it can be extremely frustrating, a little bit daunting, and that you can use as much clarity as possible. So we're going to be going over a federal civil procedure question today. It's slightly modified, but the point of the question is still intact, and you're going to learn the rule. We're going to get to the call of the question. We'll pull out the facts, and you'll see, that even though the facts were slightly altered just a little bit, it doesn't change the substance of the question. So let's just kind of dive right in. The next slide that you're going to see, and I'll go to it right now just so you can kind of see it. But this slide here, I just wanted to put up fast, and now I'm going to skip over it, is just an example of what you're going to get as a bar question. The first place that you want to go to when you approach a bar question is to the call of the question. So you have the fact pattern, which was that big block that you saw on the previous text. Then we have the call of the question. Can the defendants remove the case, and if so, to what court? And then under the call of the question, you have your 4 different answer types. You want to read the call of the question first, and I'm going to show you why on the next slide, but I'm going to explain it now. The call of the question really helps you understand what this question is asking and what specific area of law this question is testing. This one says, can the defendants remove the case, right? So you really want to focus on the fact that we're seeing the party, who it is, the defendants, and then we're talking about removing the case. So they want to know, can the defendants remove the case? And then you also want to know to what court. So you're going to get varying answers here. We also know, though, that if there are any possible answers that say, yes, the plaintiffs can remove, you can immediately eliminate those. So those are dead giveaways. We're also knowing that this is a removal question. There's only one area of law that I'm pretty sure you have removal in, and that's going to be federal civil procedure. So when we get to the facts of the case, if there's anything that looks like it's possibly trying to throw you off, it is trying to throw you off on purpose. And we're going to take a look at that here on the next slide. So now we get into those facts. And as we begin reading right from the beginning, we see that a man was released from prison as new evidence showed he was innocent. Wait right there. This is making me think maybe this is a criminal law question. The second sentence says, the man filed a suit against the arresting officer and prosecutor for violating his constitutional rights. Well, wait a minute. Now we might be in con law. If I didn't read the call of the question first, I would be all over the place. I would be so unfocused as a test taker, and I would be thinking to myself, well, wait a minute. Am I supposed to be pulling up crim law rules in my head right now? Am I supposed to be jotting stuff down about constitutional law? I don't know where this question is going. But since we read the call of the question first, which always kind of presents itself underneath the facts, we know that we can pay attention a little bit to the first 2 sentences because it's helpful background, but it has absolutely nothing to do with the substance. And when I say substance, I mean the meat and the potatoes, what the question is really asking about. So we don't have to worry about what this new evidence is or the constitutional rights. We don't care about any of that stuff. We really want to get into this third sentence here where it says the man. So we have the man who's the plaintiff, That's important to show. Like, who is this guy here? What party is he? He's the plaintiff. He files suit in the Southern District State Court. Okay, so that's where he brought his lawsuit against the arresting officer and the prosecutor. Southern District of the State Court. So we're in state court, and we're in that Southern District of that specific state court. It's also important to know because you can't remove from a federal court to like another federal court. So we're in proper state court, and we want to now know if the defendants, whoever they are, we haven't been introduced to them yet, can remove to federal court. So let's see. And we also know that this is proper venue right now because it says where the man lived and was originally arrested. We have the prosecutor, who's a defendant, right? We want to point him out as our defendant. So he's another party, and he lives in the Northern District State Court. Okay, so he's in another district of the same state. And then we have the other party here, the arresting officer, who lives in just a second state, it says, right? So he's not even in the same state. So he can't be in a district in that state because he's in a whole nother state. So we have the man in Southern State Court, the prosecutor in Northern State Court, and then the arresting officer who's kind of out there in some other random state. The next sentence says the arresting officer wants to remove to federal court, but the prosecutor doesn't. Okay, that's not great for removal because if I think back to my rule, all of the defendants need to consent to removal. Okay, and I'll show you that when we kind of like lay out our rule. But right now we have a problem. And I'm thinking, well, we can't remove right now because we have one party, right, the arresting officer, one defendant wants to remove, and then the prosecutor doesn't. So there's a little bit of a conflict there. I'm thinking right now we can't remove. However, if I keep reading, it says 1 month later, the man names the county. So we have another party here as an additional defendant. Okay, why are they telling me this? We have this random county named as an additional defendant. And then it says the county's attorney wants to remove the case to federal court. And all defendants agree. Okay, so now I'm thinking all of the defendants agree to the removal. It seems like they can remove, unless there's some sort of weird exception. Where are they going to be removing to? And I want to ask myself this too before I take a look at the proposed answers. Because if I take a look at the proposed answers before I get my facts straight and before I know what my rule is, I'm going to go in there and all of those answers are going to look tempting. So I'm going to go in here and I'm going to say, okay, well, it looks like the defendants now agree we can remove. Proper venue, like I said before, really was here where the plaintiff brought the case originally, right? Where he lived and originally was arrested. So I'm thinking that Southern District State Court. I don't necessarily care where the prosecutor and the arresting officer lived or live now. I'm thinking the most proper way to remove, if they can remove, and it seems like they can, is going to be to have it removed, because they all agree, to that Southern District State Court. So I'm going to go in and I'm going to look at my proposed answers, seeing if something matches this. But let's kind of go over some of our rule first, because we really need to know the rule for removal. We can't get anywhere without some basic removal rules. So section 1441A provides that a defendant, and only a defendant, can remove a case that could have originally been brought by the plaintiff in federal court. So you have to remove, a defendant can only remove from a state court to a federal court in which the case could have originally been brought. And that case in the last example could have originally been brought in that Southern District of State Court, because that's where the plaintiff lived and where the cause of action kind of arose. This next sentence here is huge, you guys. This is what's going to like make or break you getting some of these questions right. Venue is proper in the federal court of the state where the case was pending. Right? So the district court where the state court is located. Our state court was located in state court. That's right, what the example gave. But the district court in that state where the case was pending. The case right now is pending in the Southern District. That's where the plaintiff brought it. It's pending in the Southern District of State Court. It can only be removed to the Southern District Federal Court. It can't be removed to any other random district in state court, that state that they gave us in the example. Like I said, only the defendants can remove the plaintiff. If there were an answer that said the plaintiff can remove the case to federal court, no, that's a dead giveaway, you guys. Plaintiffs cannot remove cases. Plaintiffs have the options of federal court and state court when they file their case. If they decide to bring it in state court, they can't then remove to federal court. It's up to the defendants. All defendants properly joined and served have to consent to the removal. And this is why I was thinking, you know what, there's a problem here that the arresting officer and the prosecutor don't agree. So if your defendants don't agree to the removal, you have a problem. They cannot remove. However, the addition of a new defendant allows you to then kind of renew that consent if you get all of the defendants to agree. So if you add another defendant like they did in the example, and the county comes in and says, okay, well, I've been added as a defendant and now we really want to remove, and then everyone changes their mind and says, yeah, removal sounds like a good idea, you can go ahead and remove it even if they disagreed before. That's okay. So let's go ahead and take a look at our answer options and kind of see if there's something where we're thinking it's going to be a Southern District of the state court and the defendants all now have agreed, so all of the defendants can remove it. Okay, so choice A says no removal. We know that that one is going to be wrong because they're able to remove it. Remove to the Southern District State Court. Boom. That's the one we want. That's exactly what we were talking about. Remove to the Southern District State Court. The defendants can remove. They all now agree because of that of additional the defendant of the county being added. And it's the Southern District. So it's the Southern District, the district in which the case is pending in the state. Right? So the case was originally brought, could have originally been brought in the Southern District. The Southern District is hearing the case. It's pending in state court. It's not pending in any other district in state court. So it can therefore be removed to the Southern District of Federal Court. C pretty much says we can remove it to any district in state court, and that's not true, because if that were the case, we can remove it to, the Western District, the Eastern District, the Northern District of state court, and those districts would not have jurisdiction. Venue wouldn't be proper there. For all we know, there's no one residing in Western or Eastern District, and none of the action or occurrences kind of arose in like the Eastern or Western District. So it wouldn't be any district. That's way too broad and it's way too burdensome. We're not going to make all of the defendants and the plaintiff transfer their case now to some random district in the state. And then finally, D says to any district in state court, and we know that's wrong because that's still too broad, or second state. This one's interesting because that one defendant, I think it was the arresting officer, lived in second state. We know that this is wrong because it's proper venue for the case to be removed to the district where the case is currently pending, right? So you have the case currently pending in state court. You're going to remove it from that state court up to federal court in the same district. It's going to be in the same district, you guys. So it's going to be that Southern District State Court. Okay, I hope this helped a little bit. I hope you have a better understanding of federal civil procedure, of removal. And then I also really kind of just hope you have a better understanding of going through law school questions and bar exam questions, understanding that you look at the call of the question first, understand how you're trying to figure out what area of law they're testing you on by reading the call of the question. Don't read any of the answers. Jump right back up to the facts. Find the pertinent facts. Don't get sucked into any red herrings or anything that's going to kind of like throw you off your game. Highlight. Check for parties, check for districts, right? Check for venue, check for any key facts that really pertain to the call of the question. And then as you're going through that, kind of pull the rules back up in your head or jot them off to the side, on some scratch paper, and remember, okay, wait a minute, this sentence is in here for a reason. This might be a problem that both defendants don't agree. But wait a minute, now they're changing the facts on me, and the county now all of a sudden agrees. Why is that important? That's important because now everyone agrees again, so it can be removed. Well, where can it be removed to? It can't be removed anywhere. That's too broad. It can only be removed to where it was already first pending, and that case was already first pending in the Southern District. So it's helpful just to kind of jot those things down. And then when you kind of do that mentally, quickly in your mind, go to your answers and see what lines up. Say to yourself, okay, wait a minute, I've already decided there's removal that's possible in this case. So I'm not going to get sucked into any answer that says no removal. And you might be able to eliminate half of your answers based on that. In this question, we weren't, but you might be able to in future questions. And then if you know that it's too broad to bring it in any district, you can eliminate C and D just by process of elimination. And you can say, you know what, B has to be the only right answer here. So go through that process for each question, and I'll be posting more questions as well, so we'll get more practice together. But I definitely hope this helped. Subscribe, keep following, keep doing more practice questions. It's really, really what helps. The more practice you do, the better you're going to get, and you will pass the bar exam. Good luck, you guys.